In a previous video, we explained how you can avoid probate by using beneficiary designations on some of your financial assets.
Right.
But that doesn't really help with real estate. And so today we are going to address how you can avoid the probate process and your beneficiaries can avoid your estate being sent to probate if you own real estate.
One simple way to avoid probate for real estate in some states is what's called a transfer on death deed. What this deed says is that upon your death, you will designate who that property will transfer to. That is a deed drawn up by an attorney or a title company, recorded with the county recorder as part of your real estate. Not every state, Amber, allows that.
And not every attorney recommends it in every situation.
Mm-hmm. So what we have found with the attorneys we work with, Amber, is that if there is more than one person who is going to receive that real estate, then a transfer on death deed is probably not the best way to transfer real estate outside of probate. So if you have one child and you're leaving it to that one child, great. That might be a very simple, less expensive way to do it. But if there's more than one person, many attorneys recommend a better alternative.
And this might be a good option for you if your only asset is your real estate.
Mm-hmm.
If you don't have any other financial accounts or retirement accounts and your only real asset is real estate, this might be an option for you and you might want to discuss it with your estate planning attorney.
One other thing, Amber, is maybe you live in one state and own just real estate in that second state, right? So it's just that one piece of property in a second state. Again, that might work if that state allows a transfer on death deed. But we want to talk about probably the better option that most attorneys would recommend for people who own real estate, and that is
a living trust.
A living trust.
A living trust is a legal document which places ownership and control of property into a trust to be managed during an individual's lifetime and after death. Now, this means if you put your real estate in a trust, you can still, as the trustee, you can still sell the real estate, you can transfer it, you still have full control over that real estate if it is in a revocable living trust.
Now, Amber, let's talk about some of the benefits of a living trust before we talk about some of the positions inside of that. So a few benefits we're going to put on the screen here is, number one, it avoids probate. That's the purpose of this video, right? Try to keep things out of probate. Probate is extremely costly and time consuming. So we want to keep assets out of probate. Again, real estate has to transfer through legal means. So there has to be a way to transfer it outside of probate. We do it through a living trust. It also provides privacy. There is no public record. If you've watched our prior videos about probate, we mentioned that when there is a probate, it is public record. People can come forward and make claims against that estate, and it can lengthen the process considerably. When a trust owns it, when you pass away, you didn't own the property, the trust did. The trust didn't pass away. No, the trust simply says this is what happens when you pass away. So the trust is able to do it very privately without public record.
So in this way, it's much more difficult to contest simply because it is not public. And often living trusts actually have no contest clauses that make it extremely difficult for people to contest anyway.
Yeah, the estate planning documents that we use, the living trust specifically says, if you contest this trust and lose, you get zero. So that's a good way to keep people from taking it to court and trying to contest it.
Another thing that the living trust does, it avoids conservatorship if you become incapacitated. And this is accomplished by actually designating a successor trustee who can take over the duties of trustee if you become incapacitated. Someone that you trust, someone that you choose, not someone that a court appoints.
And let's talk about the different positions inside of the trust, because I've used a couple of terms now like trustee and things. So really three positions inside of a living trust. The first is the grantor or grantors if you're married. And the grantor is the individual or individuals who create the trust and transfer their property to it and determine its beneficiaries. The second position is the trustee, the person in charge of managing the assets owned by the trust. And lastly is the beneficiary, and that's the individual or organization who receives benefits from the trust. So Amber, when I meet with people, we talk about estate planning, I like to point out that you can occupy all three of these positions at the same time. If you are transferring your assets to the trust, you're the grantor. If you are in charge of that trust while you're alive, then you are the trustee. If you get to live in the home and receive the benefits of that while you're alive, then you are the beneficiary. So while you're alive in a revocable living trust, most people will occupy all three positions.
Then you can choose what happens to those positions when you pass away. Who will be in charge of distributing those assets, and who will receive those assets, and in what percentage?
And not just when you pass away, Amber, right? If you should become incapacitated or not capable of managing your affairs, you would name a trustee who could step in without a court proceeding, without other legal documents, to begin managing the assets that are owned by that trust. Again, if you're still the beneficiary, the trustee would have to manage it for your benefit. Most trusts say as long as you are alive, you are the beneficiary. It's only after you pass away that you would name other beneficiaries.
So in prior videos, we discussed financial strategies that you could use to avoid probate for some of your retirement assets. Today we're talking about a living trust that actually does require an attorney. It requires legal advice. So how would someone know what is best for them? A financial strategy or a living trust, or both?
So Amber, a couple of things that we look for and the attorney will look for is, number one, do you own real estate? Right, that kind of triggers this idea that we need a living trust. If not a transfer on death, you'd probably a living trust. Second thing, do you own real estate or assets in multiple states? So think about that. If you live in Nevada and you own property in Arizona, you pass away in Nevada, a Nevada probate judge cannot transfer assets in Arizona, right? So clearly a trust could own assets in multiple states and be able to wrap everything up together. And the third thing, Amber, that they look for is, do you have a special needs for your beneficiary, right? If you want to lengthen the time period that someone would receive their inheritance or these assets, maybe you want to keep it in trust for 5 years or 10 years until certain ages. A living trust can accomplish that, again, very inexpensively as opposed to some other ways.
So if you think that a living trust might be the right fit for you, make sure you talk to a competent estate planning attorney, or you can reach out to us. We use a state guru that has attorneys in 49 states to help you with your estate planning needs.
So keeping you and your beneficiaries out of probate is just another way that we help you to make the rest of your life the best of your life.
Plan now to retire happy.